again, Judge.
Good afternoon.
It's okay, you can go ahead and take your water.
Thank you. Yes, thank you.
You're good to go?
Yes, I am.
Okay. I will start you off with a quote, and then you'll tell us your understanding of the quote and give us your views on the same now that you want to ascend to the Supreme Court. It's a quote by a U.S. Supreme Court judge, and he says, the Supreme Court is not final because it's infallible, but it is infallible only because it is final. The Supreme Court is not final because it is infallible, but it is infallible only because it is final. What do you understand by this quote? And maybe you give us your views on the same.
Okay. Now, the Supreme Court is the apex court in the country. It makes difficult decisions with far-reaching consequences. It speaks with authority. It sets precedents. Now, notwithstanding that it is a final court, there will be occasion when a further reflection of a decision made today reveals a rethink. When that occasion arises, and there might be many or few, the Supreme Court must reflect as to whether a mere change of mind should lead to departing from a past decision it has made. This is because, as the apex court, cognizance of its importance in that ladder, it is expected that the Supreme Court will have given deep thought to the decisions it makes, and there shouldn't be too much occasion for revisiting a decision made. This gives stability to the law. It allows members of the public, there is then predictability as to organize themselves, knowing that this is the position of the law in certain aspects. So, yes, the Supreme Court is not infallible. And this is not just in respect to the Supreme Court of Kenya. In America, for instance, on the question of the abortion question, Roe versus Wade, there had been immediate debate as to whether the judges themselves were right or wrong in that matter. And the debate can be as soon as the next day or the week after. But I think the position that the Supreme Court took was that there is value in stability. Let a matter settle. Let there be widespread debate before you change your mind on a matter. I say this, nevertheless, aware that if there is a matter that is glaringly a wrong position, then the Supreme Court should be able to presented with a situation where it requires to rethink its position, then it should do so. But it should not be within reviewing the matter itself. Now, when the second part was, if you could just say that quote again. So
the second part was your views, and I think you've already given that.
Yes.
What do you think of the quote?
The second aspect of the quote.
The quote says, I read the quote again?
Yes, please.
Okay. The Supreme Court is not final because it is infallible, but it is infallible only because it is final.
It is infallible only because it is final. I think that when you're placed in the position where you have the last word, and where your word is the law in certain respects, it puts you as well in a position of vulnerability, because when you make a decision that eventually revisited many years later is one that you should not have made, then you did not have the opportunity for an immediate second look, but you've had yourself to deal with it